In this lecture, we will begin to explore the various ways in which regulatory agencies in the U.S. have responded to the emergence of cryptocurrency, which is commonly referred to by the agencies as virtual currency. You will see that there is no one agency that has exclusive jurisdiction over cryptocurrencies, and that different agencies have different interpretations of what cryptocurrency is that largely reflect each agency's statutory mandate. We begin by looking at cryptocurrency as a form of money and how the transmission of money is regulated in the United States. The Financial Crimes Enforcement Network, or FinCEN, is a bureau of the United States Department of the Treasury that collects and analyzes information about financial transactions in order to combat domestic and international money laundering, terrorist financing, and other financial crimes. FinCEN is responsible for enforcing the Bank Secrecy Act, the nation's first and most comprehensive federal anti-money laundering and counterterrorism financing statute. In 2011 and again in 2013, FinCEN issued guidance clarifying the applicability of the regulations implementing the Bank Secrecy Act to persons creating, obtaining, distributing, exchanging, accepting, or transmitting virtual currencies. The guidance states that administrators and exchangers of convertible virtual currencies are subject to FinCEN regulations governing money transmitters, while users of virtual currencies are exempt. A user is a person that obtains virtual currency to purchase goods or services. An exchanger is a person engaged as a business in the exchange of virtual currency for real currency funds or other virtual currency. An administrator is a person engaged as a business in issuing or putting into circulation of virtual currency, and who has the authority to redeem such virtual currency. Note that in this context, a person can be an actual human being or a company. FinCEN's guidance makes clear that the definition of a money transmitter does not differentiate between real currencies and convertible virtual currencies. Accepting and transmitting anything of value that substitutes for currency makes a person a money transmitter under the regulations implementing the Bank Secrecy Act. So the key takeaway here is that any individual or company operating in the cryptocurrency space, other than those persons who obtain cryptocurrency to buy goods or services, is most likely subject to FinCEN regulations governing money transmitters and must comply accordingly. Ripple, a well-known payments and cryptocurrency company, provides an example of what can happen when firms fail to comply with FinCEN regulations. In 2015, FinCEN assessed a $700,000 civil money penalty against Ripple for willfully violating several requirements of the Bank Secrecy Act by acting as a money services business and selling its virtual currency, known as XRP, without registering with FinCEN and by failing to implement and maintain an adequate anti-money laundering program designed to protect its products from use by money launderers or terrorist financiers. In the press release announcing the penalty, the Department of Justice sent a clear message to all cryptocurrency firms by stating, Ripple Labs Incorporated and its wholly owned subsidiary both have acknowledged that digital currency providers have an obligation not only to refrain from illegal activity, but also to ensure that they are not profiting by creating products that allow would-be criminals to avoid detection. We hope that this sets an industry standard in the important new space of digital currency. The act of transferring money or value from one person to another also brings into play the state statutes licensing money transmitters. State licensing requirements vary from state to state, but typically include some form of minimum net worth, maintenance of a bond, annual audits, examinations by regulators, record keeping, anti-money laundering programs, and a list of permissible investments for funds received and held. State money transmission statutes are clearly triggered when a money transmitter maintains an office or an agent in a state, but a physical presence is not necessary to invoke the statute, and merely having an internet website that does not block access to a resident in a state may be enough to implicate a state's licensing requirements. Since state money transmission statutes typically apply to the transmission of money or funds, the key question then becomes, do cryptocurrencies qualify as money or funds? Well, that answer depends on the state. States are taking different approaches on the regulation of cryptocurrency, with some clarifying that the use of cryptocurrency to transfer funds from one person to another is within the statute, while others are taking the opposite position. States that allow cryptocurrency firms to register under their money transmitting statutes are seeing applications filed by entities that wish to transmit money in digital currency form. For instance, popular US-based cryptocurrency exchange Coinbase currently holds licenses in 38 US states and territories. Cryptocurrency firms do not require a license to operate in states that have clarified their money transmitter statutes do not apply to cryptocurrencies. There is a time and cost component to complying with the varied and occasionally conflicting state laws. Any entity attempting to operate on a nationwide basis may find that obtaining necessary state licenses can take 1 to 2 years or more. In addition, licensing and compliance may cost millions of dollars in legal, consulting, and other fees, not to mention the opportunity cost of having management's focus diverted away from building the business. Recognizing that cryptocurrency firms do not fit neatly into their existing money transmission statutes, the New York Department of Financial Services, or New York DFS, established a first-of-its-kind BIT license, which came into effect in 2015. The BIT license requires that those involved in virtual currency business activity in or involving the state of New York must apply for a unique license and adhere to the substantive requirements of the BIT license. The BIT license can be described as Money Transmitter Plus because, in addition to imposing requirements similar to those imposed by money transmitter regulation, the BIT license also imposes requirements tailored to the unique nature of the virtual currency business, such as cybersecurity and special suspicious activity reports. To meet the requirements of the New York DFS, entities hoping to obtain a BIT license must ensure they have a designated compliance officer to deal with issues such as anti-money laundering, have policies in place for customer complaints, and must also issue transactional receipts for potential audit. The application process is stringent and will cost approximately $5,000 to file. This will include compliance manuals, full transparency on ownership, finances, and insurance, and a long-term business plan. Upon receiving the BIT license, entities will be subject to ongoing supervision and must submit periodic financial statements. The BIT license excludes merchants and consumers that transact in digital currency, the development of software, digital currency miners, and non-financial uses of digital currencies. Reactions to the New York BIT license were mixed, with some observers arguing that it was an appropriate step to regulate a nascent industry that did not fit neatly into existing rules and regulations. However, the reaction within the cryptocurrency community was near unanimous, with most arguing that the BIT license imposes an unnecessary regulatory burden that serves as a barrier to entry for new firms who most likely cannot afford the legal fees required to obtain the license. In 2017, the National Conference of Commissioners on Uniform State Laws, also known as the Uniform Law Commission, released a Uniform Regulation of Virtual Currency Businesses Act, which is largely modeled off of the New York State BIT license. The act is designed to provide for uniform state laws governing the operation of a business, wherever located, that engages in the virtual currency business. The act contains a reciprocity provision that allows an entity licensed under one state statute to also do business in another state without applying for a virtual currency-specific license in that state if both state statutes are based on the Model Act. However, states are not required to enact the Uniform Law Commission's recommendations, and to date, no state has adopted the Virtual Currency Businesses Act. As the virtual currency industry continues to evolve and mature, I expect some states will adopt the act or some version of it.